right. Well, thank you to everyone joining us this evening. Good evening and welcome to Champaign Public Library's webinar on legal help, setting up a power of attorney with John Lafond. I want to always thank Land of Lincoln Legal Aid for offering these programs. This is a monthly series we offer on the third Tuesday of every month. My name is Tricia Duzan, and I'm the Adult Services Manager here at the Champaign Public Library. And just want to point out a few things here for the Zoom features. Should be located, depending on your device, down at the bottom of the screen. You can see that there's a raise hand feature or a chat or that you can use. John will be presenting this evening, and then we can take questions. Like I said, there is a chat that you can utilize to send questions directly to myself and John, and we can see those, and I can pass on questions as needed. Just another reminder, this webinar is recorded and will be available on our YouTube channel, and that can be found by going to YouTube and searching Champaign Public Library. It's also directly linked from our, I believe, our homepage at champaign.org. And without much more talking, I'm going to go ahead and pass this over to John so he can get started.
Hello there, John Lafond. I'm an attorney with Land of Lincoln Legal Aid. Been working there for 35 years. And today I've been asked to talk to you about power of attorney. A power of attorney is a document that someone may draft and sign that gives authority to another person to be able to make decisions or take action on their behalf. It's like you give that person the legal right to stand in your shoes. And there's two major varieties: a power of attorney for property to take care of financial business, and a power of attorney for healthcare to deal with healthcare decisions. It's a good idea to consider having these documents as part of your estate plan, because you don't know. It is possible that you may someday become disabled or need somebody to help you by making decisions for you. In the case of a power of attorney for property, that may be taking care of all kinds of financial business for you. And a power of attorney for healthcare, if you can't tell the doctors what you want them to do or what you don't want them to do, this can give an agent the authority to speak for you. These documents don't necessarily need to be drafted by an attorney, but it may be a good idea since they may consider some things that you might not have thought of. Power of attorney is only effective for the most part during your lifetime. When your heart stops beating, your power of attorney is no longer effective. The exception to that is that a power of attorney may have some effect after you pass for certain things like organ donation or disposition of your remains, like taking care of cremation or funeral or that kind of thing. So power of attorney for property to deal with financial issues. I want to just show you what this form looks like. So when I put this up on the screen, my face, as I understand it, will disappear, but you'll be able to see the document. And let me pull that up for you. To the second here. Well, okay, this is the power of attorney for property statutory short form. It hasn't changed much over the years. The power of attorney for healthcare form has.
John, sorry,
yeah.
I don't think that came through as the share. Can you go ahead and make sure that is showing up?
It's not getting shared yet. Okay. Well, I don't know why. Okay. Okay, well, I thought I had mastered that.
And I should say, for those of you joining, if you can see it, if you can chat and let me know in the chats box, that would be great, because sometimes it does appear differently from my point of view. So let me just make sure.
Okay, I'm going to try to pull up the form for you.
There we go. Great, John. Thank you.
Okay, now I'm sharing. Sorry about that. So the power of attorney for property statutory short form, you don't need to use it, but people are going to readily recognize it and accept it. You can use a different form if you like. And a power of attorney from another state is recognized by Illinois, and Illinois power of attorney should be recognized in another state, as long as it's validly executed according to the laws of the state it comes from. Every state has what we call a savings clause, where they recognize powers of attorney from other states. Our form starts with a statement which explains some things to the person who is signing the power of attorney. It explains some things that you really should think about before you sign it. It would give broad powers to the person who is your agent to handle your financial affairs, which could include power to sell or dispose of real estate or personal property, and they don't have to check back with you every time they do something. And if you use the statutory short form, you may name successor agents. That's where someone would take over if something happened to the person you had named as your agent originally. The agent is the person that you've given the authority to stand in your shoes to take care of business. You can't use the short form to name co-agents, but like I said, you can use your own form. And in that form, you could name co-agents. But there's some problems with that you should consider. If you name co-agents, they might disagree with each other, and then might have to go to court to resolve a difference of opinion that they have. It's just like if you remember Dr. Dolittle, there was a creature called the push-me-pull-you that had two heads, and it wouldn't get anywhere unless both of those heads decided to head in the same direction. That's the same problem that you have if you name co-agents. They have to agree with each other about everything. So the power of attorney for property can be misused. And I see cases where, sadly, it has been misused by someone who takes the authority that they've been given and they misuse it, either to take property that belongs to someone else, or to sell it, or to borrow money, or do anything else that the document allows them to do. Now, you can name anybody to be your agent, but that doesn't mean that they have to do it. If you sign a power of attorney and name me your agent, I'll say, thank you, I'm flattered, but I'm not going to be your agent and I won't do anything. So you should discuss it with your agent before you name them, so that you know that they are willing to do this for you. And it needs to be somebody that you can trust. They don't have to be perfect, but they do have to be reasonably careful to put your interests first before anybody else, and to do a good job. And that means that if they don't know what they're doing in some particular area, they need to get advice from somebody that does. That's so that everything is taken care of correctly. They're also going to have to keep written records of whatever they do when they're acting as your agent. And under certain circumstances, those records can be requested and they may have to produce them. There's a number of people that have a right to request those records. You do. A worker with the Adult Protective Services agent, these are people that look out after seniors and disabled people to make sure that they aren't being mistreated. They can request these records. Also, if you have someone else who is your fiduciary, like a guardian or somebody like that, they could request those records as well. Or if you named a new agent, they could ask for all these records from your previous agent. And if those people didn't give the records to them, then they could be taken to court and they could have to pay for costs and legal fees involved in getting them to provide those records. Unless you say differently, the power of attorney would be in effect during your lifetime as long as you live. Now you can limit it. You can do something called a springing power of attorney. The springing power of attorney is not immediately effective when you sign it, but it only springs into action when something else happens. That can be where your doctor signs a letter saying that you're no longer able to make or communicate responsible decisions concerning your financial business. Or you could decide that you want it to become effective and then sign a statement that you want that to happen. There are some people that don't want a power of attorney for property unless or until they really need it. And you can do that with a springing power of attorney. Now, you also have a right to fire your agent if you choose to do that at some point. That's called revoking the power of attorney. And the best way to do that is in writing, and it's going to be necessary to inform third parties that you've revoked the power of attorney so that they know that they should no longer be dealing with this agent. It is probably the best practice to notify third parties first before you notify your agent, just so they don't have time to misuse the power of attorney after they've been notified, but before third parties know. So you should be aware that this gives a lot of power to your agent. So you really have to trust them. You have to be able to trust them with your money. Now, despite the fact that this is called power of attorney, it doesn't make your agent, that's the person that you've given authority to stand in your shoes, it doesn't make them an attorney. They can't appear in court for you. You would need an attorney to appear in court for you. They can't engage in the practice of law unless they are also licensed to practice as an attorney anyway. And in that case, they would be expected to use any special skills or talents that they have when they're acting as your agent. So we have explanations about what all these things mean. And you are asked to put your initials next to that statement that indicates that you understand what trouble you're getting into when you sign this document, potentially. Now, this document, you would start out with your name and address, and it starts out by saying that you revoke any previous powers of attorney that you may have done. Obviously, it would be confusing if you didn't do that, because different people would have a different power of attorney in effect at the same time. That would be confusing for third parties, and it would be difficult also. So then you would name that person that you're naming as your agent, and it needs to be a person who is an adult, who has not had a guardian appointed for them, so they are competent. Other than that, you can choose anybody you like. It doesn't have to be a family member. It doesn't have to be somebody that lives in the state of Illinois. Or even necessarily in the country, although in that case, they may need to designate a person that could be sued, that would be served with service of process if there was going to be a lawsuit involving the power of attorney. And it lists all kinds of different business that you might have your agent handle. And this is intended to be a comprehensive list, which governs just about any kind of business that you might have and a lot of things that you might never need. The important thing about this list is that you can cross out any power that you do not want your agent to have. For instance, if you do not want your agent to be able to handle transactions concerning your real estate, the house that you own, you could cross that out, and this power of attorney would give them no authority to do that. A power of attorney can be used to sell real estate if you allow that. If it's going to be used for that purpose, then the document has to be recorded with the Recorder of Deeds office in the county where the real estate is located. And there would be a fee for recording the document, but then they would scan it, and then third parties would know that you had given that authority to someone to be able to take care of that business for you. Financial institution transactions, that's business at the bank. You may also be able to do that other ways. But if you put somebody on your account with you, then they're a joint owner of the account with you if you set up a joint account. And then from a legal standpoint, that money belongs to them as much as it belongs to you, and they could take any of it out. If you give them authority pursuant to a power of attorney, they're supposed to put your interests first. They're supposed to keep written records of everything that they do, and they can be liable if they misuse that authority. Stocks and bonds, tangible personal property, that's any kind of property that you can touch, like a car or a piece of furniture or a painting. Safe deposit transactions, if you have a safe deposit box, insurance and annuities. And a lot of these things you might not think that you're going to need them today. But if you were planning ahead and you wanted somebody to be able to take care of business for you, you might not have business with an insurance company today, but you might at some point in the future. And if you should become disabled, you might want your agent to be able to deal with the insurance company or with the retirement plan. Now it lists Social Security here, but Social Security is a federal program, and they don't necessarily recognize the power of attorney as giving the authority that's necessary because they are federal. They might say, oh, you have a power of attorney. That's very interesting. We don't care. We would rather that there be a representative payee appointed to manage someone's Social Security benefits. Although informally, people do manage Social Security for other people through a bank account to which it is directly deposited. Tax matters, claims and litigation. Again, you might not have anybody that you want to sue or that you think might sue you, but that could happen in the future, and you might want your agent to be able to handle that. Commodities and options, that's like pork bellies and futures and things like that. Business operations, you may not need that. Borrowing transactions, you might or might not want your agent to be able to borrow using your credit. You really have to trust somebody if you're going to let them do that. Estate transactions, that would be dealing with somebody else's estate, usually, since your estate plan is not supposed to be interfered with by this power of attorney unless you have given some sort of specific authority for that. And then, just in case you forgot anything, all other property transactions. Now, you can leave specific instructions about what an agent should or shouldn't do. And it gives you an example of something to think about. You could say that there is, although they may generally have a power to handle stock or real estate, that they may not sell a particular stock or piece of real estate, or they may only do it under certain circumstances, or there may be special conditions that you put on their authority. You can put anything you want in there. And it is a legal document which has a legal effect on what authority that person has and what they can do with the power of attorney. Whenever I do a springing power of attorney, I put real conspicuous notices on there that let everybody know before they read further in the document that it's not effective unless those conditions are satisfied. Now, as far as granting additional powers, besides all those things we talked about, there are a couple of things that I put in here sometimes. Generally, your agent does not have the authority to make gifts, although they can make conditional gifts as allowable under the statute if you give that authority, or they can't change your estate plan unless you say that they can, like changing who the beneficiary is on a life insurance policy or something like that, or change a trust. But say, for instance, we're talking about a married couple, and one of them goes into a nursing home, and Medicaid is going to help to pay for the cost of care at the nursing home. In that case, that spouse who's in the nursing home can transfer property and income to the spouse who's in the community, and it won't affect their eligibility for Medicaid. Under those circumstances, you may want to specifically authorize that so that that could be done under those specific circumstances. And there is particular language that I put in there for that. Or in some cases, there would be an adult son or daughter who's going to help take care of an aging parent in their home. And in that case, the Medicaid rules would allow for that home to be transferred to them if they have lived with their parent for 2 years and taken care of them, so that it was not necessary for them to go into a nursing home as soon. So there are some things that you might want to put in there. Delegation. That's where your agent, the person that you've given authority to stand in your shoes, and I know just informally, sometimes they call that person the power of attorney, but the power of attorney is the document, and that person, the legal name that we would use for them is they are the agent. If you give them the right to delegate, they could tap somebody else on the shoulder and make them your new agent, and they could take care of business for you the same way that your agent could. Now, that might be convenient under certain circumstances, or there might be somebody that you've named your agent and they may be unavailable at certain times. Like, say, for instance, there's somebody that could be called up for military service. But maybe you're not comfortable with anybody else acting as your agent, in which case you might want to cross this out and not let them do that. If they name somebody new as your agent through delegation, then either you or your original agent could revoke that agency if they choose, or fire them. You just have to decide what you would want in that case. This next part about being entitled to reasonable compensation for services rendered as agent, I always cross that out. I cross it out for two reasons. The first reason is it's going to give everybody a headache if you leave that in there. What is reasonable compensation? How much do they get paid for doing what? For this, for that, or for the other thing? And to avoid the headache, I would cross it out. And then also, you can give money to that person anytime you want to. But if you cross this out, it means that they can't say, where's my paycheck for acting as your agent? And most of the time, the person that you choose as your agent would be serving as a volunteer. And if you leave that in there, then they may decide a different definition about what reasonable compensation is. And then you've got a problem. Like I said, unless you say differently, the power of attorney becomes effective when you sign it, and it lasts as long as you live, unless you choose to revoke it or to take the power of attorney and to fire the agent and let third parties know they no longer have authority to act as your agent. If you are going to have it be effective under some other circumstance, you can define that specifically in there. What I usually would put is that if there is a doctor, your doctor signs a letter saying that you're not able to manage your affairs, I would suggest that because something could happen suddenly that would make you disabled to the point where you can no longer take actions to tell people that you now want the power of attorney to become effective. Like if you had a stroke. If you had a stroke and you're no longer able to speak or to write, then you can't tell somebody, now I want this power of attorney to become effective. So there has to be another way. And that's a good thing about having a power of attorney is if you become disabled, then someone can help you. Or if you have difficulty taking care of things on your own for whatever reason, you can give somebody else that authority and they can take care of it for you right now. I do this regularly with credit card companies. I don't like dealing with them. So I tell the person on the phone, I give my wife authority to take care of this business with you. And then I hand the phone to her and I don't have to worry about it anymore. You can name different people to take over in order if something happens and your agent is no longer able to help you, either because they die or if they should become incompetent, they're no longer able to make or communicate responsible decisions, or if they quit or if they refuse to serve. It's always good to have successor agents if you can think of somebody, and you would want to list those in the order that you would want them to serve. But it's always less complicated if you have one agent at a time. Otherwise, you're going to have a problem if they disagree. The next issue is whether or not you would want to nominate the person who is serving as your agent to act as guardian without having to pay for bond or security if you're going to have a guardian. Now, a guardian is different from an agent. A guardian can only be appointed by a judge if the judge finds that you are incompetent, that you're not able to make or communicate responsible decisions, and a doctor has signed a certificate saying that they believe that that's true. And in that case, you can nominate a person to serve, and that's just putting in your 2 cents about who you think should do it, because the judge is still going to have to decide who your guardian would be. And it would have to be somebody who is qualified to serve under Illinois law, and it would have to be somebody that the judge believes would be able to pursue an active and suitable course of guardianship. If you make this suggestion, then they would not have to buy insurance. That's what a bond or security is, although they still would be responsible for doing a good job as your guardian. Now, usually, if you have a power of attorney and you've named an agent, you would not need a guardian because they could take care of your business for you. Your agent could. And so it would eliminate the need for costly proceedings where somebody would go to court to be appointed your guardian to do that. So this is just putting in your 2 cents about who you think should do that. And if you have a power of attorney that says that, then they wouldn't have to buy insurance. If you had both, if you have a power of attorney and someone petitions to be appointed your guardian, if your power of attorney is valid, that you were competent when you signed it, and that agent is willing and able to act, then they continue to have the authority that you gave them. Because actually a power of attorney trumps a guardianship. And if you had both, then your agent would keep the authority that you gave them. And if you also had a guardian, they would only get authority that was not given in the power of attorney, if necessary. Then you say that you understand everything that's in the power of attorney. You have to sign it, but you can sign it even if you're not able to legibly sign your name. Any mark that you make that's intended as your signature is a valid legal signature, but somebody else is going to have to witness it to show that you actually signed it. And in this case, you need at least one witness. The witness cannot be somebody who is your agent or successor agent or somebody that is providing some kind of health care to you. And there's a long list of people that are not qualified to act as your witness. It also shouldn't be somebody who is your close relative, because they actually have an interest in your estate. If you didn't have a will, the people that are most closely related to you would inherit those things that you have. So that means that they have a conflict. Illinois only requires one witness and it has to be notarized. But you can have more than one witness because other places may require that. They would accept it if it's valid under Illinois law, but you can have 2 witnesses if you choose. And then you need to have somebody notarize it. Otherwise, it would not be legally effective. You have the option in the form, although it's not required, to provide an example of what your agent and successor agent's signatures look like. And you can sign to attest to that. And that is something that you could do if you choose. Most cases, that's not necessary. And I'm going to stop sharing for a moment here. It's not necessary because any third party could require your agent to sign an affidavit that says that the power of attorney was valid when it was executed, that it hasn't been revoked, that they are your agent, and the third party is entitled to rely on the document in that case. So we've talked a lot about a power of attorney for property. Now, it may be that some people may have questions. I notice we have a note in the chat, just to call to your attention. They have notaries over at the library by appointment for a small fee. You can also find a notary at a bank. You may be able to find a notary at other places. If somebody gets a power of attorney done through our office, we have several notaries in our office and also several people that would be qualified to act as witnesses. You have to be competent in order to give a valid power of attorney. Everyone is presumed to be competent under Illinois law if they're an adult. Now, some people may or may not be able to make or communicate responsible decisions, even if nobody's been appointed their guardian. And the capacity that somebody has to have in order to make a valid power of attorney, they don't necessarily need to be able to handle all their own business, but they need to understand what the power of attorney is and what it does, and be able to make a decision about whether or not they want it and what they want in it. There are times that somebody may be suggested that they would like to have a power of attorney, but when we meet with them, we don't think that they have capacity or the necessary capacity to do that. It's always good to act early rather than to act too late. There are some conditions that people may have that you know are just going to get worse. Like if somebody has some kind of dementia like Alzheimer's, they may be able to understand about a power of attorney and decide that they want to give one to someone in the early stages. Later on, when the disease has progressed, they may lose that capacity and not be able to do that. So it's important in a case where someone is beginning to lose their capacity, they should meet with someone who can help them to do a number of different things. Part of it would be estate plans, part of it would be planning for future incapacity or disability. Power of attorney is one of the things that can be used to do that. And then also, if it is anticipated that they might need long-term care in the future, they're going to need to talk to somebody that knows all about that to help them to make the appropriate plans and to prepare for that. And applying for Medicaid is terribly complicated. So there are a number of different things that it may be useful to seek some professional counsel in that situation. Our office is available to provide assistance both to people who are financially eligible for service through our office or who qualify because they are 60 years old or older. And I notice that we also have our website has been provided helpfully by the library. So you have that handy, and it would show also the phone number that you call. My secretary, Kathy, would usually take intakes for seniors. We roll out the red carpet for everybody who is 60 or older so that we would do the intake for you if you contact our office personally. So that's power of attorney for property. Did anybody have questions about using power of attorney for financial business?
Thank you, John. As I say, if anybody has a question, you can either raise your hand and I can let you talk, or you can put it in the chat, and I'm happy to read that out. So please feel free to use either of those features, and we can get those questions answered. Thank you, John, for that's a lot of information. I know it can feel very overwhelming, especially for folks that are having other concerns that lead up to the need for power of attorney as well.
Sure. And like I said, for those who are eligible for service through our office, it's free of charge. And we would provide individual counseling and assist with drafting the document or helping with other issues.
So far, so we're good with no questions at this moment.
Well, let's talk about power of attorney for healthcare then, because we have another kind. So I'm going to try to share my screen again, and we will see how well that works out.
I like to blame Zoom for doing updates.
Yeah, okay. Fine.
While John is getting that, I will let you know too that, as I said, we have these legal help series the third Tuesday of the month, and next month we will be having expungement of cannabis records. So that'll be our next one. And there we go, John. I do see it now, so you're good.
Okay, boy, I'm getting to be like a pro here. We actually use a little bit of a hybrid form at my office. The language which appears at the beginning of this document is required for any power of attorney for healthcare, even if someone uses a different form. But you don't have to use exactly the same form. They've made a lot of changes in this statute over the years. In my office, we're not happy with all of them because I think that they've intended to try to make the form a little bit more user-friendly for people who are not attorneys, but in doing so, they've left out a little bit of detail that we like to put in there because you can let somebody know what kind of healthcare you want and what kind of healthcare you don't want ahead of time. And that's what the power of attorney for healthcare is useful for. Now, you might have heard of something called a living will. A living will is what we would call a declaration. It is a statement that basically says that if you have a very serious health condition, that your condition is terminal, your death is imminent, it can say that you do not want extraordinary measures taken to prolong your life. And it can provide some specific detail about that. If you had both a power of attorney for healthcare and a living will, the power of attorney for healthcare would be effective as long as you had an agent who was willing and able to serve. Once again, the agent is the person who is standing in your shoes, who can speak for you. And the advantage of the power of attorney for healthcare over the living will is that it's much broader. It can handle any healthcare decision that you yourself could make. It's not just limited to decisions that have to do with life support. It can deal with any kind of healthcare decision. If you had a guardianship and a healthcare power of attorney, once again, the healthcare power of attorney trumps the guardianship. Now, in this case, there is a law which does provide that if you didn't have a living will and you didn't have a power of attorney for healthcare, you have nothing, but you became disabled. So a doctor believed that you no longer were able to make and communicate responsible decisions about healthcare, that certain people could, under the Healthcare Surrogate Act, be given the authority to make decisions on your behalf. And they have a list of different people that would get that authority. And it starts out with whoever your agent is, your guardian would be, pursuant to a guardian of the person, if you had a guardianship of the person. Second in line would be your spouse. Third would be adult children. Now, you probably should only have one spouse at a time, so you don't have a problem with a disagreement in that case. But you may have several children. You may even have an even number of children. And two of them may think one thing and two of them may think another thing. And they can be deadlocked. And that would require somebody to go to court to get the authority to make that healthcare decision for you. So you even go down a list of people that towards the very end, it's just somebody who says that they're a good friend of yours. And maybe you want that person making healthcare decisions for you, maybe you don't. The advantage of the power of attorney for healthcare is you can tell everybody what you want and what you don't want. So now this gives you some questions to think about what's important to you. And in thinking about these questions and talking with your agent or your family about these questions, they'll get some better idea about what your opinion is about these issues. And you're not going to be able to give somebody direction about all the decisions that might come up and what they should decide. You're going to be able to give them guidelines about how to decide. And part of how you do that is you let them know what your opinion is about different things. And you may not have thought about these things before. And maybe you have thought about them because you've had a family member or a friend that was very ill and was not able to speak for themselves, and there was a conflict among the family about what to do. And in some cases, that can be a real problem in the family if there is a disagreement. So it's important for people to know what you think about these things. And it's also important for you to have thought things through so that you know what you think about these things ahead of time. So, and it gives you some things to think about who should your agent be. Has to be somebody who's an adult. It can be a family member, but it doesn't have to be. It could be a friend, or it could be anybody that you know and trust, and that would do a good job carrying out your wishes. And it should be somebody that you have discussed acting as your agent and that you're comfortable with them. Now, I know that there's some people who think about this and they think, well, you know, I've got to start with the oldest child and then I've got to take them in order of age. Not necessarily. You may know people in your family or your friends, and you know who has sound judgment on these matters. Some people might have special knowledge or expertise because they may be in the healthcare field, but not treating you specifically. And it has to be somebody that's comfortable with this responsibility. You don't want it to be somebody that's going to be so emotional at a time when you're very ill that they fall apart and they can't help you. And so you just need to think about who it should be. And so I have a special form that we use with respect to healthcare decisions. Now, this is also something that you would see in the statutory form, they're going to have many of these same things, but they're not going to have some others where we add some more specific detail. You can readily get this form at a hospital, or they're going to provide them. They may have them at your medical provider. A lot of times you go in for a medical procedure or for treatment, they're going to ask you, do you have a power of attorney? Because they want to know if somebody has this authority so that, if necessary, they could contact that person to make a decision for you if you're not able to speak to tell them what you want. Your agent, unless you say otherwise, would have access to your medical records. And we have a lot of specific language in here concerning HIPAA, which is a law that has to do with confidentiality and medical records. Now, some people do not want their power of attorney for healthcare to be immediately effective. I think that there's less of a problem with having it be immediately effective than there might be with the power of attorney for financial business. That's because any healthcare decision that there is to be made, you're going to be right in the middle of it. And if you are able to tell the doctors what you want, you are the boss. And that's even if your agent is in the room and they have a different opinion. They are only an agent. And so your authority supersedes whatever authority that they may have to act as your agent. So say, for instance, you'd given somebody power of attorney for healthcare. Doctor comes into the room and says, you know, I'm really concerned about the condition of your leg. There's gangrene. I think we're going to have to amputate it. And your agent says, yeah, let's do that. And you say, no. They should not take any action that you disagree with, and you can tell the doctor that you don't want it. You also can revoke your power of attorney at any time you choose, and they make revoking the power of attorney easier than revoking the power of attorney for finances, because you can direct somebody else to execute a written instrument or even sign it for you. You can just rip up the power of attorney, or you can deface it, and those would have the effect of revoking the power of attorney, the same as if you had done that. Or you can do it orally, but you want third parties to know that you've revoked it. Some of the choices that your agent might have to make. Do you want to be an organ donor? And you can choose specifically what you might want to donate if you were going to do that. Or you can say, no, I do not want for my agent to donate any of my organs. Now, obviously, if you got to be in a position where they were considering organ donation, you wouldn't be able to speak to it. So if you want to let people know what your preference is, now is the time to speak. And that's why you can designate that on your driver's license so that people would know that you've made that choice if you decide that you want to do that. And they also would have the authority to authorize an autopsy and direct the disposition of your remains, unless you say otherwise. Usually the government isn't going to require an autopsy if you've been seeing your doctor regular and they don't have any questions about whether or not you've been a victim of foul play or they have some concerns about whether or not you may have a serious disease that other people could catch, or if they think that you were poisoned or something like that. Now, I recommend that you might want to give your agent that authority. And the reason that I would say that is that, say, for instance, you were in a hospital or a doctor was treating you. What if the doctor made a mistake, and as a result, you died or you were seriously hurt? You would want for there to be an autopsy if you died, so that there would be the necessary evidence that would prove your case if somebody should be liable because there was medical malpractice, for example. And you could decide also that you don't want to give your agent this authority. This, as far as being able to disclose information, you can limit that if you choose. Now, the next question is there some type of medical treatment that you would not want to have under any circumstance? And you can designate anything you don't want to have. It could be for a religious reason, like a Jehovah's Witness might say, I don't want to receive a blood transfusion. It's against my beliefs. You can put something in the power of attorney so that your agent could not do that. They would have no authority to authorize that on your behalf. You can put anything in here that you want your agent to know you don't want it, and they don't have any authority to authorize it. For example, some people have been through a course of treatment, something like chemotherapy. They really hated it. They don't want to go through it again. Now, if you're able to tell the doctors what you want and what you don't want, you can tell them. But if you weren't able to tell them, you can say ahead of time to your agent, I don't want this. And they won't be able to authorize it. Now, as far as life support decisions, we talked about how that is a subject under the living will. If you have both of these documents, it's like a belt and suspenders, because the living will only be effective if your agent is not able to, or willing to act, or if you don't have a power of attorney for healthcare. You can put whatever statement you care to in here that explains under what circumstance you would want to receive treatment and when you wouldn't. This can be whatever you want, but it's going to provide direction to your agent. They're still going to have to make decisions, because you can't specify ahead of time everything that might possibly happen. Just not creative enough to think of all those things. And if you did, your power of attorney would be pretty long. So there are a few major positions that people take. The way I would describe this is it's a question of how should your agent make this decision if it comes up. If you tell your agent, the main thing I'm concerned about is I want you to prolong my life to the greatest extent possible, then you can say that, and they'll try to do whatever they can to prolong your life as much as possible without regard to your condition, if that's your preference. We've added some language to our document, which is recommended by the AMA, the American Medical Association. And the reason for that is that if they provide you relief for pain, and a lot of people that are close to death, depending on what condition they have, they may be going through some pain. If they're going to give you sufficient pain control medication so that you're not uncomfortable, that may actually shorten your life. You know, a lot of people may be given something like morphine if they're in a lot of serious pain. If you take enough morphine, that will actually shorten your life. So this kind of clarifies that. Now, on the other hand, you might say, give some different things that you want your agent to think about in arriving at this decision. Because there are going to be two experts in the room if you're in a situation where these life support questions come up. One of those experts is your agent. They're an expert in you and what you like and what you don't like. The other expert is the doctor. They're an expert in your medical condition and in your prognosis and whether or not you're likely to get better and what your life would be like if it continues. And they may be able to assess risks and benefits. I imagine that your agent is going to be talking closely to the doctor in any event. But the question is, do you want them to rely on your doctor's judgment about these issues? Or do you want them to rely on their own sound judgment, taking into consideration what they've learned by talking to the doctor, what they know about you and what you like and what you don't like, and all these other things that you might think that are important for them to think about, like whether or not you are suffering, whether there's some expense involved, what the quality of your life as well as the extension of your life would be if your life continues. There were some cases which arose before the power of attorney for healthcare statute, where there was a young woman that was in a car accident in Missouri, and she was on life support. And so the question was, should she be taken off of life support? And there was no one under the law at that time that had the authority to decide that. So it had to be decided through the courts. And then when authority was given to discontinue that life support treatment, she continued to breathe on her own. You know, these issues are not easy to decide, and there's no one right answer for everybody. It used to be pretty simple to tell whether somebody was still with us or not. The only medical equipment you might need is a mirror to see if somebody's still fogging it up, if they're still breathing. But we have technology that can stand in for the things that your body does yourself. And it may be that you would need that when you're really sick in order to recover. Now that may also be true with respect to things like eating and drinking. You could be so sick that you can't eat or drink, and they could provide water to you intravenously or through a gastric tube or a nasogastric tube, and they can also provide nourishment the same way. Even as far as whether or not artificial nutrition and hydration, food and water, under the Living Will Act, those aren't considered to be medical treatment, because as you think about it, I mean, food and water kind of delay the dying process for all of us. If you don't drink or you don't eat, you won't live for a certain amount of time after that. You might be able to go without food maybe for 30 or 40 days. You might be able to go without water for a few days, but a lot of the medicine that they give you to control pain is administered intravenously. And if you're seriously dehydrated, even though people can't come back and tell us, You might be uncomfortable, just as you know, if you're really thirsty and your lips get chapped and you are dry. But then also your veins can collapse so you can't get medication. So you might want to say, I would want to have food and water in any event. Once again, you have a choice that you can decide when you want it to be effective. You can have it be effective immediately or only if something else happens. And you can decide when it should end. Once again, like the other power of attorney, you can put in a suggestion about who your guardian should be. And this does not have to be notarized, but it does have to be witnessed by at least one other person. And that person cannot be a person who is participating directly in providing medical care to you, or who is related to somebody like that, or who is one of your agents, or who is somebody that is closely related to any of the above. So you can have it notarized if you choose. It's not a legal requirement under Illinois law. So that sort of introduces some of the subjects that you would have to think about with the power of attorney for healthcare. And then you would want doctors or hospitals or places where you're getting treatment to have a copy of that. And they suggest that you could have a note on your refrigerator that says that you have a power of attorney for healthcare. You could stick it in the freezer or the refrigerator, because a lot of time EMTs will know to look there to see that you have one, or you could have a card in your wallet that says you have one, because people aren't going to know unless they see it. And it's a different thing if you're talking about DNR order than a power of attorney for healthcare. Because if you went into the emergency room, they'll do whatever they can to stabilize your condition, to get your heart and your breathing going, and then they'll call your agent. So a DNR, that's something else. You have to review it with your doctor. So do we have any questions about power of attorney for healthcare?
Sure. Thank you, John, very much. So I'll put it out to the group. If there's any questions, please feel free to raise your hand or use chat. Give it just a minute here for everybody to catch up. It's a lot of information, I understand, to cover in our time frame, so it is a lot to take in. John, I think we're good for questions. I have posted your website on there if people need to reach out, and thank you for talking about how to contact you and everything as well. Do you have any final parting words as we wrap up this evening?
I would just say that I mean, nobody likes to think about the possibility that they may become disabled, but it is good to plan ahead for it, because it happens to a significant proportion of people at some point during their life, or it could happen temporarily. And it's always better to plan ahead, because then you get what you want, and you get the person that you trust to speak for you under those circumstances. And that's the most important thing.
Yeah.
You can't speak for yourself.
I think that is, and like you said, it's hard subject matter. We don't want to necessarily think about these things, but the more proactive we can be, the better off we are. So thank you, John, again. That's a great presentation and help. So I appreciate you taking the time to be here tonight, and of course, Land of Lincoln Legal Aid as well for offering these sessions every month. As I mentioned, our next legal help topic is the expungement of cannabis records. That'll be held on Tuesday, April 19th from 7 to 8 p.m. That will actually be an in-person event. Starting in April, we're getting back to some of our in-person events happening here at the library. And you can find out more information at our events page at champaign.org. And that particular one will be held in room C on the main level. So be sure to check that out. I don't believe we have a registration sign up for that. So you can just show up at that time. And again, thank you, John, so much for this evening. And without further ado, I'll let everybody go, and we will see you maybe next month.
Thank you.
Thank you very much.